Hi, welcome to Group 8's presentation on statutory interpretation. My name is Sarah Zulaika and I am Group 8's leader, and this is Megan Koo. And next, we have Hannah. Next, we have Tisha. And now, we have Ivan. And last but not least, we have Patricia.
Hello everyone, my name is Hannah and I'll be introducing statutory interpretations to you. Now, what are statutes? Statutes are a major source of law. Parliament makes law while judges apply it. What is the definition of statutory interpretation, you may ask? Basically, it is the process by which judges apply law made by Parliament. Interpretations are needed when words are unclear, outdated, or ambiguous. Each year, Parliament passes about 60 acts and 3,000 statutory instruments. Judges must often interpret legislation to find its true meaning. Now, there are several rules which judges use to interpret statutes, but for my part, I'll be focusing on the literal rule. Now we'll be looking at the literal rule. The definition of the literal rule is judges must give words their plain, ordinary, and grammatical meaning even if the results seem harsh, absurd, or unfair. For example, in the case of Fisher and Bell in 1961, where the shopkeeper, Bell, displayed a flick knife with a price tag in his shop window. The law made it an offense to offer for sale such knives under the Restriction of Offensive Weapons Act 1959. However, the court held that he was not guilty because the display of goods is merely an invitation to treat, not an offer. Here, the judges applied the literal meaning of the word offer. Now, we'll be looking at the advantages and the disadvantages of applying the literal rule. Firstly, we'll be looking at the advantages. One of them is it respects Parliament's sovereignty as laws are applied exactly as Parliament wrote them. For example, in the case of United Biscuits and Customs and Excise Commissioners in 1991, where the courts had to decide whether the Jaffa cake was a cake or a biscuit for tax purposes. They applied the ordinary meaning to the word cake and decided that the Jaffa cake was indeed a cake and not a biscuit. This showed respect for Parliament's exact wording in tax law rather than making a new interpretation. After that, it also encourages precision in drafting, since Parliament knows judges will interpret words literally. Lawmakers must be careful and precise in choosing language when drafting statutes. Finally, it creates legal certainty and predictability. People, businesses, and lawyers can easily understand what the law means because judges apply it consistently. This makes the law clear and consistent. However, there are a few drawbacks to applying the literal rule. It can lead to absurd or unfair results. For example, in the case of London and North Eastern Railway Company and Berryman in 1946, where a railway worker was killed while maintaining the track, but his widow couldn't claim compensation because the law only applied to workers who were relaying or repairing the track. Since he was only maintaining, the court said she wasn't entitled, which was a very harsh and unjust outcome that resulted from applying the law literally. Another disadvantage is that the literal rule fails to adapt to changing social conditions or modern context. In the case of Whiteley and Chappell in 1868, the defendant impersonated a dead person to vote. The law made it an offense to impersonate any person entitled to vote. The court found him not guilty because technically a dead person is not entitled to vote. The literal interpretation created an absurd result that clearly went against common sense and modern standards of justice. Finally, the literal rule ignores the broader purpose or spirit of the law. By focusing only on the words, it can make the law rigid and mechanical, even when Parliament's real intention is obvious but not perfectly expressed. So we know that the literal rule plays an important role in upholding Parliament authority and keeping the law certain and consistent. However, as it may produce unfair results, other interpretation rules are sometimes needed to reach a fairer outcome.
My name is Tisha and I'm going to be presenting the Golden Rule approach. So what is the Golden Rule? The Golden Rule came from the case of Gray and Pearson in 1857. Lord Wensleydale said judges should follow the literal meaning of words unless it leads to an absurd result. This rule has two forms. One, the narrow interpretation, where the judge chooses the most sensible meaning to avoid small absurdities. And two, the wide interpretation, where judges can adjust the wording to prevent serious unfairness. Its purpose is to simply avoid unreasonable outcomes, though it can sometimes lead to judicial lawmaking which worries those who believe Parliament should change the law. Now, I'll move on to the advantages and disadvantages of this rule. First, the advantages. This rule helps avoid absurdity by preventing unreasonable or illogical outcomes that might also occur if the law were interpreted too literally. It also preserves the intent of the Parliament because judges try to follow the purpose behind the law rather than relying on the exact wording. However, there are also disadvantages. There are no clear guidelines for when the rule should be applied, which means judges have a lot of discretion. This can lead to inconsistency. Additionally, it may lead to judicial lawmaking where judges effectively change how the law works. This raises concern about the separation of powers, since making laws is supposed to be Parliament's role. Now, let's move on to the case of R and Allen that used the wide golden rule approach. In this case, the defendant was charged with bigamy. The literal rule made the offense impossible because a second marriage is legally invalid. The court applied the wide golden rule and interpreted the word marry to mean going through a marriage ceremony. The court held that the defendant was guilty because the statute clearly intended to punish those who attempted to marry again while being already married. An example case that we can look at for the narrow golden rule approach is the case of Maddox and Storer. In this case, the defendant was driving a minibus and went over the speed limit and argued that the law only applied to vehicles adapted to carry more than 7 passengers. The court used the narrow golden rule approach, interpreting the word adapted to also mean designed to carry that number. The court held that the defendant was guilty because the vehicle fell within the intended meaning of the statute, avoiding an absurd loophole. Thank you.
Hello everyone, my name is Megan. My section focuses on one of the most influential rules of statutory interpretation, which is the mischief rule. This rule dates all the way back to 1584, where it established in the landmark case of Hayden's case. Unlike the literal and golden rules, which focus primarily on the language of the statute, mischief rule allowed judges to go deeper and interpret the law in a way that it tackles the problem of the mischief the act was intended to remedy. So, why does mischief rule exist? It's used in situations where the wording of a statute isn't perfectly clear. Maybe it's too general or ambiguous. Rather than strictly following the literal meaning of the act, the court asks, what problem was Parliament trying to fix? This allows the judge to enforce not just the words, but the intention of Parliament. Hayden's case provided the foundation of the mischief rule. In this case, the judges were interpreting the statute of monopolies, but the wording was unclear. So the court had laid down 4 questions, which still guide mischief rule today. So, what are the 4 main questions? The 4 main questions are: number 1, what was the common law before the act was passed? Number 2, what was the mischief or defect that the previous law had failed to address? Number 3, what remedy did Parliament provide to fix the problem? And lastly, number 4, what was the true purpose behind that remedy? In other words, what was wrong with the old law? What new law did Parliament introduce to fix it? And what purpose should the courts fulfill when interpreting the new act? Now, let's look at the modern application of the mischief rule. In the case of Elliot and Gray, in 1960, the defendant had parked his car on the road. The car had no battery and it had no insurance. It was propped up on the road with car jacks. He claimed that he was not using the car as it was not actually being driven on the road or being used on the road. Therefore, he was not committing an offense under the Road Traffic Act, which required insurance for cars used on the road. Using the mischief rule, the court said the purpose of the act was to prevent any insurance disputes and protect the public, not just to regulate vehicles in motion. So, even though the car was not drivable, it was still creating the same risk. The court found him liable finally, and the mischief was the lack of insurance, not the lack of use. So now, let's move on to see a different case. This is also another famous mischief rule case, and it's called Smith and Hughes. In this case, prostitutes were calling to men from balconies and windows above the street. They argued that they were technically not soliciting in a public place, as how the act had worded it, because they were inside private residences, their own homes. Applying the mischief rule, the court said Parliament had passed the Street Offences Act to clean up the streets and prevent harassment to the public. Whether the prostitute had stood on the street or yelled from the window, the mischief was still the same. So, courts had interpreted the act in line with its purpose, not just its literal wording, but its actual intention, and finally, courts held them to be liable.
Hello, my name is Patricia. So today I'm going to tell you about the purposive approach. So the purposive approach is where the judges interpret the law to determine the Parliament's intention. And it is an European approach that is adopted by the European Court of Justice to interpret the European law. When the UK joined the EU, it highly influenced and affected the English court. There are two aims regarding this approach, which is the first one is to retain the certainty of the law, and the second one is to ensure that the judges do not contravene with the separation of powers. In the case of Diocese Hallam Trustee and Connaughton, a woman is employed by the plaintiff as a press officer. After she resigns, a male successor has been appointed at the same role and has a higher salary. She then challenged this under the Equal Pay Act 1970 on the grounds of disparity of pay between genders that constituted to sex discrimination. Held, the Employment Appeal Tribunal allowed this comparison, although the man is not appointed or employed at the same time. And the tribunal used the purposive approach to eliminate the sex-based pay discrimination. One of the theories that gave comments on purposive approach is Lord Denning. In the case of Seaford Court Estates Limited and Asher, he quoted a statement which is basically a statement that supports the purposive approach that retains the certainty of the law and how it is used to interpret the law. So now moving on to the advantages and the criticism of the purposive approach. So the advantages is that it promotes justice and fairness, where the judges can make decisions that is fair and justice, and that it avoids absurdity in outcome, where the judges can remove the absurdity of rigid interpretation of the literal rule, where it can have decisions that are fair and justice, And then it reflects the legislative intent, where it maintains the main focus of interpretation of the law that are based on the Parliament's intention. And then on the criticism that it is uncertain and also inconsistent because judges can infer different purposes and also ideas that could lead to unpredictable outcomes. And then it conflicts with the parliamentary sovereignty because judges may overlap their powers, and also it can disturb the separation of powers. And then lastly, it has less reliance on statutory meaning because reliance on external sources such as the Hansard can introduce biasness and selective interpretation in complex political cases. Thank you.
Hi, I'm Sarah, and now we'll be talking about intrinsic aids. Now, what's the definition of intrinsic aids, you may ask? Intrinsic aids are features within the statute itself that judges may use to clarify the meaning of words or provisions. They are not formal rules, but helpful interpretative tools. There are a few key types of intrinsic aids. First of all, the long title. The long title basically explains Parliament's general intention. For example, the Theft Act 1968, where it is an act to modernize the law of theft. Next up, we have preamble. A preamble is common in older statutes as it sets out Parliament's purpose. Modern statutes, however, do not usually include one, or if they include one, it's usually a brief summary version of it. Then we have headings and schedules. Headings before groups of sections can guide interpretations. Schedules, on the other hand, are attached to acts to provide detailed clarification. Besides that, we have marginal notes. Marginal notes are comments in the margins explaining sections. These are not authoritative since they are added by printers after debates. Judges may use these as helpful, but they are not binding. Last but not least, we have interpretative sections. These are rare but significant. For example, in the Arbitration Act 1996, in Section 2, it sets out the principles of the Act. These encourages purposive interpretation by explicitly stating the aims. Judges often refer to intrinsic aids when wording is ambiguous. For example, in the case of Powell and Campton Park Racecourse in 1899, the long title and context of the Betting Act helped clarify the meaning of house, office, room, and other place. The Betting Act 1853 made it an offense to keep a house, office, room, or other place for betting purposes. Powell was charged with keeping a betting place at Tattersall's enclosure in Campton Park Racecourse, which was an open-air enclosure. The issue is, did the phrase other place in the statute include outdoor areas like racecourse enclosures? The case established the adjustum generis rule, where general words follow specific words in a statute. The general words are interpreted to include only things of the same kind or class as the specific words. Here, other place was limited to indoor places, not outdoor places. The House of Lords held that Tattersall's enclosure was not covered by the Act. The words house, office, room all referred to indoor places, so other places had to be interpreted in the same category. Therefore, Powell was not guilty of the offense.
What are extrinsic aids? Well, as mentioned before, intrinsic aids are help to interpretation found inside the legislation. Extrinsic aids are those found outside the legislation itself. Now, there are a few examples. Dictionaries to interpret the literal meaning of those words, sometimes having one or more meaning. As mentioned before in the literal rule, sometimes applying those literally may be unjust or unfair. There are textbooks, journals, and encyclopedias which contain the academic writings of different ways of interpretation, opinions, and explanation by experts in the legal field or ex-judiciary members. There are also international treaties like the Geneva Convention or the ECHR, which will be mentioned. The ECHR will be mentioned later on. There are also law reports on how the past judges interpret the same legislation of interest, and also case laws or called precedents. There are also Hansard. Now, there's a case that illustrates a multitude of these extrinsic aids. The case of Magla and others against Dawali and others. Now, what happened in this case? Well, a Sikh boy's admission to a private school was rejected by the headmaster on the grounds that the keeping of long hair and the wearing of turbans was against the school's uniform policy. The father, enraged by this, brought a claim against the headmaster and the parent company of the school under Section 1 Sub 1 of the Race Relations Act 1976. The county court judge ruled in favor of the headmaster as the Sikh was not found to be part of the definition of racial groups in Section 3 Sub 1 due to recent norms within the Sikh community that we will explain later. The Court of Appeal then dismissed the father's appeal on the grounds that a group can only be part of the racial group under Section 3 Sub 1 if they have a distinguishable racial characteristics that is peculiar to that group, but the Sikh did not possess any of that. In the appeal to the House of Lords, it was allowed. The Lords discussed the definition of the term racial group, and then in reference to the definition in Section 3 Sub 1, focusing on the word ethnic. Lord Fraser, which is the judge of interest in this case, used a variety of extrinsic aids. Before all the judgment and reasoning in the report, there was a usage of an encyclopedia, Hosbury's Law, to determine the definition of racial discrimination. The consultation of Oxford English Dictionary, supplementation of English Dictionary, Volume 1, Concise Oxford Dictionary was used to lay the foundation of the definition of those two words. Now, there was a reference to a case law, Ailing London Borough against Race Relations Board, where the judge proceeding, Lord Simon, referred to another statute which is also a type of extrinsic aids, where the predecessor of the Race Relations Act 1968, which is the predecessor, the long title of that predecessor act, to determine the definition of a racial group. Now, finally, the social practice of the Sikhs. Now, the social norm currently for the Sikh is that wearing of turbans and keeping of long hairs are more so discretionary and optional. It's not a strict requirement of practicing anymore in comparison to wearing hijabs for women of Islam. Let's take a look at Hansard, another type of extrinsic aid. Well, it is a collective archive of parliamentary debates on a passing of bill or a legislation. Judges or members of the legal system may refer to it to interpret the intention of Parliament during the making of that legislation. For example, Fisher and Bell, as mentioned earlier, the Restriction of Offensive Weapon Act 1959, it is stated that you are not to sell, manufacture, or offer to sell flick knives, which what the defendant was accused of. Well, does it include the display of knife? Well, technically, the display of knife was an invitation to treat and not an offer. If Hansard was available during that time, it would not be a big deal, and there would be easier to determine the intention or the things that the Parliament wanted to cover. Now, why was Hansard inadmissible in court before the landmark case of Pepper v. Hart? Well, we will mention that case later. Well, it was because it's in breach of Article 9 of the Bill of Rights, where that the freedom of speech and debates or proceedings of the Parliament ought not to be impeached or questioned in any court or place out of Parliament, meaning it covers parliamentary sovereignty, parliamentary privilege, and the separation of powers. Now, there's three bodies of the legal system. There is the judiciary, there's the legislative, and there's the executives. If the judiciary were to interpret the debates and words of the Parliament, the legislation, it means that they will make new laws, if they got it wrong. Well, it goes against the doctrine of all three of them.
Now let's take a look at the case of Pepper and Hart, where reference of Hansard is allowed to determine the legislative intent. So in this case, Hart and 9 others were the teachers in Melbourne College, and they are benefited under the concessionary fee scheme, where their child is educated with a lower price. And then the Inland Revenue challenged this benefit under the Finance Act 1976. So, how Hansard may be used in this case because there is ambiguity in the legislation and the statement relied upon is made by a minister or the promoter of the bill. So, the statement is unequivocal. Therefore, in Hart's case, the use of Hansard is allowed to interpret the statutes in line with the minister's statement. Therefore, Hart is not liable under the higher tax assessment.
A unified contextual approach is a modern interpretation method as to use the literal rule, then golden, then mischief. It goes through each rule one by one, starting off with the literal rule, and then the golden rule, and then the mischief rule. In Section 3 of the HRA 1998 Compatibility Approach. Section 3, Subsection 1, so far as it is possible to do so, primary legislation and subordinate legislation must be read and given effect in a way which is compatible with the Convention rights. Section 3 of the HRA stated that if a primary legislation or an Act of Parliament was to be interpreted to be in line with the Convention rights. If it is not in line, then a court is still to interpret it to the best of their abilities to be just and to make a declaration of incompatibility under Section 4. So what is Section 4? Section 4 is the Declaration of Incompatibility. If a delegated legislation was to be in conflict against a convention right, then it is considered void, and that public or authorities may not act in a way that compromises convention rights as per Section 6, which talks about the voiding of delegated legislation and authority action. So, to provide you with a case example, let's look at A and others and Secretary of State for the Home Department, House of Lords, or well known as the Belmarsh case. In this case, prisoners were held without given trials as suspected to be terrorists under Section 23 of the Anti-Terrorism, Crime and Security Act 2001, where there is authority to detain any foreign nationals in suspect of terrorism indefinitely. It is considered incompatible with the Article 5 of Human Rights Act, and the courts had to apply and rule in favor of the Home Department, but then made a declaration of incompatibility. Hence, it was replaced by the Terrorism Act 2005.
Now, let's get into verbal maxims. What are verbal maxims, you may ask? Well, it is a guiding principle or rule used by judges in court to interpret the meaning of words within a legal text or ambiguous or unclear language in statutes by applying the logical or linguistic reasoning. There are 4 verbal maxims. Now, there is adjustum generis, which is the first verbal maxims, which is established in the case of Powell and Kempton Park Racecourse. What is the definition of this? Well, specific items will be followed by general words. For example, dogs, cats, and other animals. The other animals' parts may be assumed as other domestic pets. It is to prevent overly broad interpretation and anchor general words to specific context. Now, the limitation to this is that sometimes the word or intention of the words may have a different interpretation than the one that the courts applied. The next one is Nocestas et Suis, which is established in Penley and Bell Punch Co. Limited. The definition is that the meaning of words can be understood by looking at the words surrounding the statute. For example, that you look at the context of the sentence or the entirety of the paragraph to determine what the intention of the parliament was. For example, cup, plate, and dishes will be interpreted as tableware rather than serving of food. It is to prevent misleading reading of words and anchor the meaning in a more contextual, logical sense. Now, but the limitation is that the surrounding words must form a clear group. Now, the next one is expressio unius est exclurio alterius. Now, this was used in R against inhabitant of Sicily, which this means that the expression of one thing excludes other things. For example, if a statute explicitly mentions certain item, it is presumed that the items not mentioned were intentionally excluded by Parliament. If a statute lists specific items, the court assumes anything not listed is excluded. For example, no vehicle except ambulances may enter. Other vehicles are excluded because they are not expressly mentioned. This promotes clarity and precision in the legal interpretation, and also prevents courts from adding extra words into categories that are not in statutes. Now, in pari materia, meaning same subject or matter, well, the definition is that you're supposed to use the statutes that are based on the same matter or aim or goal and read them together and interpret them together as if they form a body of law. The statute should not contradict each other. So the purpose is to ensure consistency and harmony across related statute and help resolve ambiguity in similar aims or content. The limitation, however, it cannot be used if the statute have different purposes or conflicting provisions. These are our references, and thank you.